can feel my face when I'm with you, but I love it.
Hello my lovelies, hope you're having a great day. Today we discuss a case law on dying declaration. If you want to see our previous videos, the previous 3 videos on dying declaration, remember you can always watch them in the playlist on dying declaration. Just go over to the playlist page and you'll find a playlist over there on dying declaration. Nevertheless, for your convenience, I will add a link to the top right corner of your screen right now. Today we discuss the case of Tehal Singh versus State of Punjab. This is a Supreme Court decision and the citation will be on screen for you. Let's start with the facts of this case. This one is based on a rivalry between workers of 2 different transport companies in Punjab. On one side was the transport company of Chiman Lal and Murari Lal with their friends Tehal Singh, Darshan Singh and Gurmail Singh. Try and remember their names because it will help you with the facts of the case. On the other side was the company of Preeti Singh and Harmail Singh. Once there was an altercation or a fight between Preeti Singh and Darshan Singh on a minor issue. In this fight, Preeti Singh slapped Darshan Singh and Darshan Singh left in a vengeful mood. Later, Darshan Singh came back with Tehal Singh and the other friend Gurmail Singh with guns and iron rods. Tehal Singh shot Preeti Singh and Harmail Singh and one other friend of theirs. After they were shot, Darshan Singh and 2 others beat up these already shot people with iron rods. 2 of the 3 shot people died. The only one taken to the hospital was Harmail Singh. On doctor's intimation, the head constable of the police station nearby came and took the statement of Harmail Singh in the presence of the medical officer after his certificate of fitness. In his statement, Harmail Singh gave all the details of the crime scene. After which, due to his serious condition, he was transferred to a big town hospital where he died. Now, on the basis of the dying declaration and various other evidence, Tehal Singh was convicted of Section 302 IPC and sentenced to death. Darshan Singh and Gurmail Singh, the people who beat up the shot people with iron rods, were given life imprisonment by the Sessions Court. This sentence of death and life imprisonment respectively was confirmed by the High Court. The matter reached the Supreme Court. Now, the evidence available before the Supreme Court was as follows. Number 1. Testimony of Preeti Singh's 13-year-old son who was present on the crime scene when his father was being shot and beaten with iron rods. Number 2. Gun pellets and blood from the spot. Number 3. Postmortem report which confirmed gunshot wounds and a beating with a blunt object like iron rod. And finally, the dying declaration of Harmail Singh. Defense raised the following objections. Number 1. The wealth of information in dying declaration suggests that it was not made by a dying man. Number 2. There was no expectation of death while making the statement. Number 3. The statement was not recorded in a question-answer format. And number 4. That the evidence of the 13-year-old boy should be disregarded due to personal motive to implicate the accused. Supreme Court went on to hold. Number 1. In the present case, they said that the mere wealth of information in the dying declaration does not lead to the inference that the dying declaration is fabricated. The Supreme Court further said that in certain situations, the wealth of detail may arise suspicion about the dying declaration. On the other hand, the circumstance that a statement contains wealth of detail cannot necessarily lead to inference that the statement is a fabricated one. Number 2. The Supreme Court further clarified, as we have also discussed in our previous videos, that Section 32 of the Evidence Act does not require a statement should be made in expectation of death. Number 3. On the question of the fact that the statement of the dying declaration was not recorded in an question-answer format, the Supreme Court went on to hold that even though the statement was recorded in a narrative format does not mean that the head constable recorded something other than what Harmail Singh or the dying man said. All that it means is that the language was of head constables, but the substance was that of what Harmail Singh said. The court did not think that any infirmity is attached to the dying declaration on this account. And if you remember, we discussed it last week. Dying declarations recorded in narrative format may have reduced evidentiary value, but does not become irrelevant. And in this case, there was a lot of circumstantial and non-circumstantial evidence available for corroboration. Number 4. The court also upheld the evidence of the child witness, the 13-year-old boy Hardeep Singh, who was the son of Preeti Singh. The court went on to hold that a perusal of his evidence showed that he has certainly attained a measure of mature understanding, and he had been thoroughly cross-examined as well. Thus, the court upheld the decision of High Court and stuck with death sentence for Tehal Singh and life imprisonment for the other two. If you enjoyed this video, give us a thumbs up and subscribe to our channel. That gives us feedback and encourages us to make more such videos. See you soon.